Dulgheriu and another in London Borough of Ealing.
May it please your Lordship and my ladies, I represent the appellants in this appeal, together with my known friends Mr Henderson and Mr Fallbrook. The respondent is represented by my known friends Mr Bowes, Ms Bogar and Ms O'Leary. I propose to assume, if I may, that I don't need to say anything specific about the background to the case, and that your Lordships would have had an opportunity in particular to read the judgment and the skeleton arguments, including the skeleton argument of the intervenor.
Yes.
And thus, unless I can assist your Lordship and my ladies any further with any of that material, I was proposing to turn without more ado to our grounds of appeal.
Very good, thank you.
So I turn to our first ground of appeal, which, as you all know, addresses the question whether Section 59(2)(a) of the 2014 Act applies to one-off or very occasional visitors to the area in question, such as the women who attended this abortion centre for abortion procedures or advice. Lord and my ladies, I'll come to the statute in a moment, but can I show you first the white paper which preceded it, which you will find in the joint bundle of authorities behind tab 3. And you will see from page 17 of the bundle that the white paper was published by the Home Office, the sponsoring department, in May 2012. And can I take you to page 18 of the bundle, where you will see that the then Home Secretary's foreword began by saying no one should have to accept graffiti on their walls, public drunkenness on their streets, or harassment and intimidation on their own doorstep, but for too many communities in this country, such crime and antisocial behaviour remains a fact of everyday life. And then at the end of the foreword, antisocial behaviour, this is top of page 19, still ruins too many lives and still damages too many communities. And then what we've included in the bundle is the section of the white paper which addressed what became public space protection orders under the Act, but at the time of the white paper were called community protection orders, public spaces in brackets. I should just indicate to your Lordship and my ladies that the previous section, you see the final part of it above C44, was addressed to community protection notices. So what was proposed in the white paper very much was reflected in the statute. The two different forms of community protection, let's say community protection notices first, and then what became public spaces protection orders second. I can show you if you want. I've got copies of the section addressed to the first of those, but what we've copied begins at C44 with what the white paper had to say about the second. C44, the community protection order, public spaces, is intended to deal with a particular nuisance or problem in a particular area that is detrimental to the local community's quality of life by imposing conditions on the use of that area which apply to everyone. So you will see what was envisaged was an order that would protect the quality of life of the local community, and indeed what was intended was that it should be called a community protection order. And then at C46, you will see the test for issuing the order will be that the local authority reasonably believes that the behaviour is detrimental to the local community's quality of life, and that the impact merits restrictions being put in place in a particular area. So again, what was the objective intended by at least the white paper was that such an order would protect the local community's quality of life. And then the second sentence of C46, the behaviour must also be ongoing or persistent, or there must be a reasonable belief that future behaviour will be ongoing or persistent. So the focus there is on the behaviour being ongoing or persistent. When we come to look at the Act, of course, we'll see that the relevant section provides that the effect of the behaviour must be ongoing, continuing or persistent. But you will see from the white paper that what was intended was that essentially that it should be the behaviour that should be ongoing or persistent. Now, we submit that a one-off or even a very occasional visitor to a centre or indeed to any location within a community, a local community, is self-evidently not and will not be a part of or a member of that local community.
But Mr. Havers, that sentence, the final sentence in C46,
Yes.
the behaviour must also be ongoing or persistent, or there must be a reasonable belief that future behaviour will be ongoing or persistent. Yes.
And that's reflected, I think, we can check it when we get to the Act, but that's reflected in the Act. But as I understand it, the basis of the order made in this case was not that the Council foresaw that there would be such behaviour in the future, albeit that there hadn't been such behaviour hitherto. It was that there had already been, over some lengthy period of time, the activities being carried out that the Council was concerned about. Can I then, and this is slightly out of order, I appreciate, but I think it may be more helpful to look at the explanatory notes before looking at the statute itself. I invite you to turn to tab 2 in the same bundle. And of course, these are the explanatory notes that accompanied the statute itself. And on page 12, you will see in paragraph 1 that they were prepared by the Home Office, that's to say the sponsoring department of the statute. And can I take you first to page 13 of the bundle, paragraph 160. You will see reference to the first of the two ways in which the explanatory notes explain the Act was intended to protect a local community or its quality of life. Firstly, by means of a community protection notice, and we'll look at that in more detail when we come to the statute. And then over at page 14 of the bundle, paragraph 173, we see what is said in the explanatory notes about public spaces protection orders. And 173 reads, the public spaces protection order referred to as the community protection order public spaces in the white paper. So the explanatory note is equating the two quite clearly. Is intended to deal with a particular nuisance or problem in a particular area that is detrimental to the local community's quality of life by imposing conditions on the usage of that area. So although the statute, as we will see, uses the phrase those in the locality, the explanatory notes, consistently with the white paper, uses the phrase the local community's quality of life. And we find that repeated in paragraph 177 at the top of the next page, page 15. The two-part test for issuing the order will be that the authority is satisfied on reasonable grounds that the activities carried on or likely to be carried on in a public place are detrimental to the local community's quality of life. So again, the explanatory notes are equating plainly the phrase used in the statute with the phrase the local community. Can I then take you to the statute itself, which is behind tab 1. And what I propose to do is just take you through the relevant sections without any comment, and then go back to those sections which we specifically rely upon. And what we've done is we've copied part 4 of the Act, which, as you will see, is headed Community Protection. And Chapter 1 begins Community Protection Notices, and you will see Section 43(1), and I'll come back to this in a little more detail later, sets out and indeed the rest of Section 43 sets out the powers to issue a community protection notice.
Mr. Hayes, I can feel that they haven't fixed the air conditioning.
No, they haven't. I asked.
We've been asking them to do it, and they haven't done it. It's a really hot day, so if council want to take their wigs and gowns off, you're perfectly entitled to do so.
Thank you very much indeed. So if I could take you then over to Chapter 2, beginning at page 3, Public Spaces Protection Orders. Public Spaces Protection Orders, Section 59, Power to make orders, 59(1). A local authority may make a public spaces protection order if satisfied on reasonable grounds that 2 conditions are met. The first condition is that, little a, activities carried on in a public place within the authority's area have had a detrimental effect on the quality of life of those in the locality. And that's the key phrase for the purposes of our first ground of appeal. Or that it's likely that activities will be carried on in a public place within that area and that they will have such an effect. That's the looking forward part of the provision that my Lady Justice Nicola Davies referred me to earlier in the White Paper. Subsection 3, the second condition is that the effect or likely effect of the activities A is or is likely to be of a persistent or continuing nature. B is or is likely to be such as to make the activities unreasonable, and C justifies the restrictions imposed by the notice. Then subsection 4 provides what a public spaces protection order may do. It may prohibit specified things being done in the restricted area, or it may require specified things to be done by persons carrying on specified activities in that area, or it may do both. Subsection 5, which I'll come back to shortly, the only prohibitions or requirements that may be imposed are ones that are reasonable to impose in order A, to prevent the detrimental effect referred to in subsection 2 from continuing, occurring or recurring, or B, to reduce that detrimental effect or to reduce the risk of its continuance, occurrence or recurrence. 6, a prohibition or requirement may be framed so as to apply to all persons, or only to persons in specified categories, or to all persons except those in specified categories, so as to apply at all times, or only at specified times, or at all times except those specified, so as to apply in all circumstances, or only in specified circumstances, or in all circumstances except those specified. And then subsection 7, a PSPO must A, identify the activities referred to in subsection 2, B, explain the effect of section 63 where it applies. Well, that isn't relevant. That refers to the consumption of alcohol. And section 67, which creates an offence, which we'll come to in a moment. C, specify the period for which the order has effect. And that takes me conveniently to section 60, duration of orders. The public spaces protection order may not have effect for a period of more than 3 years, unless extended under this section. The order in the present case, of course, was an order for the full 3 years. And then your Lordship and my ladies will see that the rest of section 60 makes provision for extending the order, again for no more than 3 years, and it may be extended more than once. And then section 61 addresses variation and discharge of such orders. I don't think I need to read more from section 61. Can I then take you over to page 6 of the bundle, section 66, challenging the validity of orders. 66.1, and this was the route deployed in the present case by these appellants. An interested person may apply to the High Court to question the validity of a public spaces protection order or a variation of such an order. Interested person is then defined. An individual who lives in the restricted area or who regularly works in or visits that area. And then the grounds on which an application may be made are set out. And then the time limit for making such an application. And then subsection 5, the powers of the court on such an application, if satisfied that the local authority did not have power to make the order or variation, to include particular prohibitions or requirements imposed by the order, or that the interests of the applicant have been substantially prejudiced, the court may quash the order or any of the prohibitions or requirements imposed by the order. So the court has power primarily to quash the order in full, but its, as it were, backup power is to quash any of the specific prohibitions or requirements imposed by the order, and we'll look at the order a bit later. And then subsection 7, an interested person may not challenge the validity of such an order or a variation of it in any legal proceedings except under this section or under subsection 3 of section 67, which is where a prosecution has been brought for failing to comply with the order, which takes me conveniently to section 67. It is an offence for a person without reasonable excuse, A, to do anything that the person is prohibited from doing by such an order, or B, to fail to comply with a requirement to which the person is subject under such an order. 2, a person guilty of an offence under this section is liable on summary conviction to a fine not exceeding level 3 on the standard scale, which I understand is up to £1,000 at level 3. Subsection 3, a person does not commit an offence under this section by failing to comply with a prohibition or requirement that the local authority did not have the power to include in the public spaces protection order, and that's the subsection which can be entitles an interested person to bring a challenge under section 66.7. And then section 68 provides for the alternative regime of fixed penalty notices as an alternative to a prosecution. The constable or an authorised person may issue a fixed penalty notice to anyone he or she has reason to believe has committed an offence under section 63 or 67 in relation to such an order, and I think need only refer you next to subsection 6. The sum involved must not be more than £100, and then over the page subsection 11 defines who an authorised person means, and it's someone authorised for the purposes of the section by the local authority that made the order. Can I then invite you to look across the page to page 9, section 72. 72.1, a local authority in deciding A, whether to make a public spaces protection order, and if so, what it should include, B, whether to extend it, C, whether to vary it, D, whether to discharge it, must have particular regard to the rights of freedom of expression and freedom of assembly set out in Articles 10 and 11 of the Convention. And then subsection 3, a local authority must carry out the necessary consultation and the necessary publicity and the necessary notification, if any, before A, making such an order. And subsection 4 defines the necessary consultation as meaning consulting with Chief Officer of Police, and then B, in particular, whatever community representatives the local authority thinks it appropriate to consult. And then finally, can I draw the court's attention to section 73, guidance, subsection 1, the Secretary of State may issue guidance to local authorities about the exercise of their functions under this chapter and those of persons authorised by local authorities under sections 63 or 68. And I'll be showing you the guidance issued in this case under that section shortly. So, ladies and my lord, can I then take you back to the first page of tab 1 and the where you see and have seen the relevant provisions are to be found. That's to say, in part 4 of the statute, which is entitled Community Protection. And you will see that the first of the two means by which the community is to be protected is by way of a community protection notice. Can we just look at 43.1 in a little more detail? An authorised person may issue a community protection notice to an individual if satisfied on reasonable grounds that a. the conduct of the individual or body is having a detrimental effect of a persistent or continuing nature on the quality of life of those in the locality, and b. the conduct is unreasonable. Now, this is, as you see, this is giving power to issue a community protection order. In other words, an order designed to protect the local community. The phrase used in section 43A, that's to say the quality of life of those in the locality, is exactly the same phrase as is used in section 59.2a under the PSPO regime. And we submit that it would be very surprising if Parliament intended that phrase to mean something different when using it in section 59 to what it must have intended to mean in section 43, that is, essentially the quality of life of the local community. Because both measures, that's to say community protection orders on the one hand and PSPOs on the other, were plainly designed and intended to provide community protection, as the heading of Part 4 explains, albeit by different means. And it's very difficult, we submit, to think of any reason why Parliament should have intended the phrase to have a different meaning depending on whether the measure in question was a community protection notice or a PSPO. Next, can I take you back to section 59, the key section? And 59.2a provides that the first condition is that activities carried on in a public place within the authorities area have had a detrimental effect on the quality of life of those in the locality. And your Lordship and ladies will have seen that that's the expression used in the White Paper and in both section 43 and section 59. And we respectfully submit that that phrase, the quality of life, means or at least infers some sort of stable presence in the locality, rather than one or maybe two visits to the locality at most. And we submit that it's difficult to see how someone's quality of life could be detrimentally affected by antisocial behaviour if he or she only visits or has only visited the locality once or very occasionally. Lord and ladies, next, section 59.3, you've seen already, provides that the second condition is that the effect or likely effect of the activities, A, is or is likely to be of a persistent or continuing nature. We submit that really by definition this can't and won't apply to those who visit the locality only once or twice. On the contrary, it applies to those who are truly part of the local community because it is only they who will be persistently or continuously affected by the antisocial behaviour in question. In other words, you simply cannot say that the effect of the activity in question on someone who visits the locality only once or twice will be persistent or continuous. The respondent submits that this subsection doesn't assist our construction of the section because it could apply to a one-off visitor who is detrimentally affected by the activity in question in the long term. For example, some long-term psychiatric difficulty, notwithstanding that she was only exposed to the activity in question on one or two occasions. We submit that's not how the subsection should properly be interpreted. What this provision is aimed at is activities, the detrimental effects of which persist or continue. For example, take a local pub which puts on live music in the garden at the rear of the pub throughout the summer, weather permitting, of course. Now, the effects may well be detrimental to those in the locality if the music is too loud and if the detrimental effect continues or persists throughout the summer. But if the pub turns down the music to an acceptable level from the, in other words, the volume, from the volume at which the music was being played when complaints were first made to an acceptable level, then the effect would not be of a persistent, or would no longer be of a persistent or continuing nature. However, if the music isn't turned down, then the detrimental effect will be persistent or continue to be persistent or continuous for the local authority, the local community's quality of life. The effect will not be of a persistent or continuous nature, as I say, if the music has been turned down. And we submit that some assistance is to be derived on how subsection 3A should be construed from subsection 5. The only prohibitions or requirements that may be imposed are ones that are reasonable to impose in order to prevent the detrimental effect from continuing, occurring or recurring, or to reduce the detrimental effect or to reduce the risk of its continuance, occurrence or recurrence.
Where on your argument do you draw the line between people who are only occasional visitors who fall outside your interpretation of the provision and those who are not living in the locality but who are not occasional visitors? Let's take, for example, a hospital or a hospice where people may be there for some considerable time and there are people who are regularly visiting them, maybe over several weeks or several months. Do all of those fall outside the definition?
Lord, it's going to be a question of fact in every case, which is no doubt why Parliament didn't define the expression those in the locality in any way, leaving it to the local authority and on a challenge to the courts to define the, to say whether the individuals in question fall the right side or the wrong side of wherever the line should be drawn. But to take my Lord's examples, those staying in a hospice for an extended period of time, one can well see the local authority and the court saying that while they're there, they are part of the local community.
Well, I'm talking about the people visit. I'm talking about the
And
people visiting.
and I was going to go on to address visitors. If they're regular visitors over an extended period of time, then I can well see that the local authority and the courts might say that they become part of the local community. But the question for your Lordship and my ladies is obviously whether those who visited this centre, about whom this case is concerned, who on the evidence only ever visited it once or twice or very occasionally, could begin to fall within whatever was intended by Parliament by the expression those in the locality. And so wherever one draws the line, we submit that the very occasional visitor quite clearly falls the wrong side of it.
Well, it seemed by reference to your previous answer to me that the touchstone that you're applying in every case is have they not become a member of the community?
Yes.
That's what you say is the test.
It is, because it's clear from the materials that I've shown the court that those in the locality is really to be interpreted as members of the local community.
So,
Now,
for example, people working, not living in the locality, but working would be.
Correct. And we've accepted regular, in our skeleton, we've accepted, as Mrs. Justice May said in Summers, which I'll come to in a moment, that those who regularly visit would fall within the expression those in the locality. And that expression might well be broad enough to include the visitors to the...
But the touchstone for all that, I think the touchstone for all of that is to be judged by reference to whether or not they have become a member of the community.
The local community.
All right. Thank you.
I was showing you on subsection 5 of section 59, which is that, which provides that, and I've read it to you already, and we suggest that that confirms our construction of section 59.3a, because it's difficult to see how a prohibition or requirement under subsection 4 could prevent a single incident, that's to say a one-off activity, from having a long-term effect.
If I can just follow up on my previous questions.
Yes.
How would you regard, for the purpose of the definition or the qualification in the locality, how would you regard somebody who doesn't live or work in the community but always regularly shops there?
Yes.
So
Well,
every week they go in and they shop in the market town.
Yep. Well, that sorry to interrupt. That would amount to a regular visitor to the locality, and he or she would qualify in that way. As we'll see in Summers, Mrs. Justice May, as I said, said that the term must be read to include those who regularly visit or work in the locality in addition to residents. And we suggest that that's a very helpful way of approaching the proper interpretation of this phrase. So, in Lord, section 59, subsection 5, as I was submitting, also suggests, we submit, that the detrimental effect must be caused by a series of continuing or recurring incidents or activities, which by definition won't be experienced by a one-off or very occasional visitor to the area where the incidents take place. So, reading subsection 3a and 5 together, we submit plainly excludes the one-off or occasional visitor. Next, can I take you back to section 67, which creates the offence of failing to comply with the order. Now, as you've seen, the effect, therefore, of a PSP is potentially to criminalise what would otherwise be lawful conduct by making it an offence to fail to comply with an order. And that, we submit, is important because it follows, according to general principles, that section 59 should be interpreted restrictively, that's to say narrowly, rather than expansively. And the same point arises in relation to section 72, 1, where, as you've seen, Parliament has effectively acknowledged that such orders may interfere with fundamental rights, specifically freedom of expression and freedom of assembly, and for the same reason, it must follow, we submit, that section 59 should be construed narrowly rather than expansively, because such an order is likely to, indeed may well, interfere with such rights. And then section 72(3), which I showed you a little while ago, you will see expressly provides that a local authority must consult with whatever, and I'm reading from 4B, whatever community representatives the local authority thinks it appropriate to consult, and thus the obligation to consult with community representatives is, we submit, all of a piece with how we invite you to construe section 59.
Well, can you get much weight out of that once you've accepted that people who don't actually own property or occupy property within the area can, as it were, fall within the ambit of the protection? The fact that the consultation is taking place with owners and occupiers doesn't really help you very much.
Well, it doesn't take me that far, I accept. But it takes me a little way, because again, your Lordship sees the emphasis on community representatives rather than some other sort of representative. I agree, it doesn't take me very far. Now, well, that's all I want to show you on the statute itself. But can I finally, in terms of the relevant material, take you to the guidance issued under section 73, which you will find behind tab 5 in the same bundle. And this is the updated December 2017 version. And can I invite you to go to page 27, where you will see the beginning of section 2.5 of the guidance, headed Public Spaces Protection Order. And if you go over the page, you will see a number of a flow chart at the top of the page, which and the box at the bottom on the left-hand side. Council puts restrictions on an area where behaviour has or is likely to have a detrimental effect on the local community. And then purpose. Public spaces protection orders are intended to deal with a particular nuisance or problem in a specific area that is detrimental to the local community's quality of life. So it couldn't be clearer that certainly the Home Office or statutory guidance is equating the phrase "those in the locality" with the local community. Then, can I ask you to go to page 31 of the bundle? About 5 lines down, putting victims first. Although it may not be viable in each case, discussing potential restrictions and requirements prior to issuing an order with those living or working thereby may help to ensure that the final order better meets the needs of the local community and is less likely to be challenged. There are then references to the community's quality of life in the box towards the foot of the page, headed homeless people and rough sleepers, the third line. such behaviour as having an unreasonably detrimental effect on the community's quality of life. And then towards the end of the second paragraph in that box, the specific activity or behaviour that is having the detrimental impact on the community. And then at page 33, in the box towards the top of the page, headed Parish and Town Councils, you will see yet another reference to that expression, third line down, including whether a PSPO would provide the means to address the issues being experienced by the local community. And then finally, in the box just over halfway down the page, groups hanging around, standing in groups, playing games. Second line, the public spaces protection law should target specifically the problem behaviour that is having a detrimental effect on the community's quality of life. So, my lords, we submit that the materials that I've shown you plainly indicate that certainly the intention was that PSPA should be introduced to protect the quality of life of the local community. That's what the explanatory notes confirm, and that's what the guidance, the statutory guidance, confirms. I said I would take you to Mrs. Justice May's decision in Summers. It's in the same bundle behind tab 22. The case concerned a PSPO related to dog control within Richmond Borough's open spaces and the highways, and the challenge was in fact to specific parts of the order made by the local authority. But at page 264 of the bundle, 624 I think, sorry, yes, 624, paragraph 24, Mrs. Justice May said this: Mr. Rutledge for Richmond submitted, and I did not understand Mr. Porter for Miss Summers to dissent from the proposition that those in the locality must refer to some but not necessarily all of those within the locality. In my view, the term must be read to include those who regularly visit or work in the locality in addition to residents. And then she goes on, this construction is supported by the definition of those persons who may apply under section 66, which we'll come back to in a moment. Can I then invite your lordships to turn to the judgment of Justice Turner on this question, and to go for this purpose to page 122 of the call bundle. Your Lordship and my ladies will see that in paragraph 41, the judge took a point, as it were, against us in these terms. A narrow approach would also have the potential to tie the local authority's hand when attempting to prohibit detrimental activities in public areas mainly populated by visitors, for example, in the vicinity of tourist attractions, on the ground that persons in the locality have to be locals for the purposes of the application of the 2014 regime. Well, I've made submissions already as to the phrase extending beyond locals in the sense of local residents to those who work and regularly visit the area. But so far as tourist attractions are concerned, which is the example he gave, our response would be to say that there are bound to be some local residents who would also attend such a tourist attraction, for example, a fun fair in the local park. And there would no doubt be some local residents who would work in or regularly visit the locality who would do so too. And what's more, antisocial activities carried on in the vicinity of a tourist attraction are likely to have a detrimental effect on those who work at the attraction as well, some of whom may also be local residents. And as we pointed out in our skeleton, some antisocial activities will have an obviously detrimental effect on the local economy and thus on the quality of life of those who depend on the local economy. So there are various different responses to the judge's point, all of which we suggest indicate that his point was, on analysis, unsound. In paragraph 42, he takes against us the wording of section 66(1) of the Act, which you will recall provides that only an interested person can challenge a PSPO, and he helpfully sets out how that's defined in the Act, so as to save us, I think, going back to the authorities bundle, it means an individual who lives in the restricted area or who regularly works in or visits that area. As I say, he makes the point that it would have been very straightforward for the draftsperson to have used the term interested person or some similarly narrowly defined group for the purposes of section 59 rather than the phrase those in the locality. We may get some indication of what was the purpose of the expression used in section 66(1). And I'm sorry, I do need to take you back to the Joint Authorities bundle, to the guidance behind tab 5 and to page 35 of the bundle. Where just over halfway down the page, alongside the heading Appeals, the guidance provides that any challenge to the PSPO must be made in the High Court. An interested person is someone who lives in, regularly works in or visits the restricted area. This means that only those who are directly affected by the restrictions have the power to challenge. So it looks as though what Parliament had in mind when restricting those who can bring a challenge under section 66 was to restrict their number to those directly affected by the restrictions in question. Why should Parliament have wanted to do so? Well, one explanation may be to prevent, for example, campaign groups from being able directly to challenge a PSPO under section 66. But whatever the reason, we say it is wrong to seek to use 66(1) for the judge to use 66(1) to support his construction of 59(2)(a. He was confusing two different provisions. 59(2)(a), which provides, or rather which identifies those for whose protection such an order may be made, and section 66(1), which identifies those who may directly challenge such an order.
The point the judge makes is that that definition of interested person as meaning an individual who lives in the restricted area or who regularly works in or visits that area is in fact your definition.
Well, my lord, it's not quite my definition, because as I've sought to explain to the court, my definition is essentially the local membership of the local community, albeit that I accept that Mrs. Justice May's definition is a helpful definition insofar as it goes.
Well, yes, but when I asked you for examples,
yes,
I didn't understand you to be suggesting anybody who might be within the locality, or as you put it, a member of the local community who wasn't a person who either lives in the area or regularly works in it or visits it. I mean, which other category is there?
Well, it's difficult to think of any other categories, I accept. But the reason why I'm hesitant to accept your Lordship's question is because Parliament plainly chose not to define the phrase "those in the locality," and it must have had good reason for not doing so, so as to leave it to the authority and if needs be, the court to decide, as it were.
That might suggest. I'm putting to you that it was deliberately left open, as I think you would put it, whether or not there might be people who fall within the expression "in the locality" who were not living in the area, regularly working in it, or visiting it.
Well, I suppose it may depend on what one means by regularly visiting the area or working in the area, because there may be degrees of working in the area. But the fact remains that Parliament deliberately chose not to define it, whereas it did choose to define the Section 66(1) category. And the two are obviously intended to achieve different things. So, can I try and pull all those submissions together in this way? We submit that however one tries to define Section 59(2)(a), those who visit the locality only once or twice do not fall within it, because the purpose of these orders is to provide protection to the quality of life of the local community from antisocial behaviour, the effects of which, the detrimental effect of which, is of a persisting or continuing nature. 2, one-off or very occasional visitors to the area cannot be regarded as part of the local community, nor can their quality of life be said to be detrimentally affected by such behaviour. And so, as I say, however one defines Section 59(2)(a), very occasional visitors don't fall within it. Now, can I turn to the consequences if we are correct as to the question of whether very occasional visitors do or do not fall into 59(2)(a)? We submit that if we are correct, then it must follow that the order as a whole is quashed, because there's no power to make the order in order to protect very occasional visitors from the effect of such activities. Now, the respondent now says that the order was also made for the protection of members of staff working at the centre and for local residents. But we submit that it is inconceivable that the respondent would have made the order on the basis of the effect of these activities on the staff and local residents alone. On the contrary, it's clear that the respondent's overriding concern was with the effect on service users. And of course it was the privacy of those service users alone which the judge held provided the legitimate aim, the rationale for interfering with the appellant's Article 9 to 11 rights. And indeed it's impossible, we submit, to see how the claimed upset and so on said to have been caused to the staff and local residents could ever be enough to justify what the judge accepted was the significant interference with the appellant's Article 9 to 11 rights. So we say it's hopeless for the respondent now to suggest that the order can be justified on the basis of protecting the staff at the centre or local residents, because it's clear that the overriding concern was with the users of the centre, and I've used the word inconceivable, and I use it again, it is inconceivable that they would have made the order otherwise. So, Lord and ladies, those are our submissions on our first ground of appeal. Unless
well,
I can...
you accepted in the course of submissions that I think in relation to a local tourist attraction, that if there was antisocial behaviour which affected visitors, on the one hand there might be local residents who might be affected, put that to one side, but you also said that it might affect the economic interests of the people who are running the attraction, and that in itself would be something that would fall potentially within the ambit of the statute provisions. Why shouldn't that be equally true of a clinic that is offering consultancy and other services to a defined group of people who come there? Why are they, we're not talking about their economic interests, but they're still providing a service of a regular nature, and those to whom that service is aimed at are likely to be affected in turn when that might affect the viability or the rationale of the service being conducted. So why shouldn't the staff in that way be within the ambit of the mischief?
Well, to start with, there's no evidence that the economic status or the financial interests of the centre or its staff have in any way been prejudiced by these activities.
Over and above the references to the large number of cancellations.
Well, Milady, there has been there are references to cancellation, but there's nothing to suggest that the women in question didn't rebook and attend on another occasion. So there's a complete absence of evidence to suggest certainly any significant effect at all on the activities of the centre. And no doubt if there had been any such effect, then we would have heard about it, because the director of the centre, I think she's the director of the centre, has made two statements, one in the course of the consultation exercise carried out by the local authority, and the other for the purposes of these proceedings. And she certainly hasn't suggested anything along those lines. And I'm reminded that I think this is the lady I was referring to here, Sally O'Brien, says in paragraph 24 of her statement in these proceedings, the reference is page 312 of the supplementary bundle, that although they are this is a private clinic, approximately 98% of the clients are NHS funded.
Yes, I wasn't suggesting in my question to you
No.
that it was the economic interests that are affected, but I'm saying that they're providing a service, so it's an entity which is providing a service, and the service is affected, hypothetically, a service is affected by the impact of the people using the service. That's what I'm putting to you. Yes. Why therefore don't the staff within that entity, or the owners of the entity, why wouldn't they be entitled to complain?
Well, if the staff could show that their quality of life in that sense had been affected, but then they would be staff who are regularly in the locality, so they qualify in any event as members of the local community. Thanks. So, my lord and my ladies, can I then turn to our second ground, which is that the judge adopted the wrong approach to the question of whether the order in this case was justified. And can I take you back, please, to his judgment, beginning at page 122 of the core bundle. Now, paragraph 44, he's just addressed the question that I've just addressed to you, the meaning of those in the locality. And then at paragraph 44, he sets out on a review of the evidence of detrimental effect through to paragraph 54. And I don't show that to your lordship and ladies in any detail, although you will see in passing in the middle of paragraph 52 a reference to the level of scrutiny and analysis which this court must deploy as not being such as to transform its jurisdiction from a reviewing to a merits-based approach. And I'm going to come back to the proper approach in a moment. But then in paragraph 55, having carried out that review of the evidence, he says, taking the evidence as a whole, I find that the defendant had reasonable grounds to be satisfied that the conditions in subsection 59.2 and 59.3a, and those 59.2 is that the activities were carried on in a public place, having a detrimental effect on the quality of life of those in the locality. And 59.3a is that the effect was of a persistent or continuing nature, were met. I am satisfied that my findings in respect of the proper interpretation of these subsections are compatible with convention rights, the consideration of which I will embark upon later in this judgment. The decision of the defendant was in this sense thus properly prescribed by law. The issues as to whether the effect of the activities was likely to be such as to make them unreasonable, that's 59.3b, and thus justify the restrictions imposed by the notice, that's 59.3c, are inextricably bound up with the application of conflicting convention rights, to which I will now turn. So, thus far, or rather so far, so good, we would respectfully submit, because the judge has been addressing in conventional Wednesbury judicial review public law terms whether the defendant had reasonable grounds to be satisfied that those two conditions under section 59 were satisfied. Now he then, beginning at page 125, paragraph 56, addresses the question whether Article 8 was engaged, and I'll come back to that since that forms the next ground of appeal. And that continues to section paragraph 63. Then he turns to articles 9, 10, 11 and 14 in paragraph 64. But all he does is simply to set out what the Cabinet report, the Murphy report, said about these rights. He didn't set out any analysis of his own about them. I go then to paragraph 65, page 129. He then singles out the role of religion in a short section, paragraph 65 to 68, which that forms our fourth ground of appeal. He then addressed legitimate aims and competing rights in paragraph 69 to 76 and found both to be satisfied. He then addressed 59.5 and less restrictive alternatives, paragraphs 77 to 84, and then the terms of the order, 85 to 89. And then, beginning at paragraph 90, he turned to the key question, was the interference necessary in a democratic society? He cites a case in the European Court of Human Rights, Allen against Germany, which in fact was a case about Article 10, but he says that the 4 or 5 lines into paragraph 92, the relevant principles were helpfully summarised thus, and indeed the court will find a helpful summary of the principles that apply to Article 10. He didn't cite any authority in relation to Article 11, and in paragraph 93 cited more from the Annan judgment. In paragraph 94 he contrasted that judgment with the Van den Dungen case, which I'll show you when I come to ground 4, and a distinction between the two, and in particular the fact that the Murphy report had correctly noted that the Article 10 rights include the freedom to receive and impart information, although he didn't address that any further himself. And then then eventually he comes to the question whether the interference was necessary in a democratic society, and all that he does is to quote the relevant passage from the Murphy report. He didn't set out any analysis of his own. And having done so, at paragraph 97, he set out his conclusions. In the circumstances of this case, I do not doubt that there has been a significant interference with the rights of activists under Article 9, 10 and 11. I do not underestimate the seriousness of taking steps which are bound to conflict with that special degree of protection afforded to expressions of opinion which are made in the course of a debate on matters of public interest. Nevertheless, I am satisfied that the defendant was entitled to conclude, on the entirety of the evidence and information available to it, that the making of this PSPO was a necessary step in a democratic society. Just pausing there. So the approach that the judge has adopted to the question, the discrete question of whether the interference was justified, is the conventional public law judicial review Wednesbury approach. And he goes on, there was substantial evidence that a very considerable number of users of the clinic reasonably felt that their privacy was being very seriously invaded at a time and place when they were most vulnerable and sensitive to uninvited attention. In other words, that was the evidence that he considered entitled the respondent to conclude that the order was necessary and reasonably justified. And then he goes on, it also follows that in this regard, I'm also satisfied that the defendant was entitled to conclude that the effects of the activities of the protesters was likely to make such activities unreasonable and justify the restrictions imposed in satisfaction of the requirements of 59(3)(b) and C. Now, that final sentence is we suggest a mixture of the two, but probably is directly related to the remaining two conditions under section 59, which he had to be satisfied about. That is to say that the activities were unreasonable and that the restrictions were justified in domestic law, public law terms. And putting it very shortly, our submission is that in approaching the human rights issue, that is to say whether the order amounted to a reasonable justification of the interference in the appellant's Article 9, 10 and 11 rights, he simply adopted the wrong approach, because he simply adopted the same approach as he adopted for the domestic question, that's to say the Wednesbury public law approach. Now, if necessary, I can show you the relevant authority or authorities, but I suspect that at the end of the day there is little between learned friend and I as to the correct approach to deciding that question, whether the interference is justified. And can I very shortly summarise the submissions that we make as to what that proper test is? Firstly, the fact that convention rights are raised in judicial review proceedings does not transform those proceedings into a full merits review, with the court remaking the decision under challenge. But on the specific question of whether ECHR rights have been infringed, in other words, whether the interference is justified, the court is the decision maker, and thus the court must decide whether the appellant's rights have been infringed. As I say, I strongly suspect that that is common ground between us, and I don't
That's
propose...
That's the Denby High School case, isn't it?
Sorry.
That's the Denby case, isn't it?
Yeah, my lord, it's a number of cases. It's the Denby case, the Belfast City Council misbehaving,
Yes.
A and Chief Constable of Kent, which the judge cited at an earlier, much earlier part of his judgment, and a case referred to in Liberty's written submissions at paragraph 34, Galles de Gouy against Westminster City Council. But as I don't understand there to be any difference between us, I propose not to show your lordship my ladies.
Well, we can get the references presumably from your skeleton.
You can. I mean, I can. If it would assist, I can give you those references now.
Well, why don't you just
Yes.
do that?
Well, Denby High School. It's tab 11 of the Joint Authorities bundle, and paragraphs 29 to 32.
Yes.
Per Lord Bingham. Belfast City Council against misbehaving, tab 10, paragraphs 30 to 32 and 37, per Lady Hale. A and the Chief Constable of Kent, cited in paragraph 25 of the judge's judgment. And then Galles de Gouy,
So, paragraph.
25.
Yes.
And then the Queen, Galles de Gouy against Westminster City Council, referred to at tab 25, in which my ladies will find at tab 25 of Liberty's bundle of authorities, paragraph 34. 34. Now, it's a relatively short point, but not only do we say that it's clear that the judge adopted the wrong approach from the terms of paragraph 97 itself, but also we don't find anywhere in the judgment any passage where the judge himself has addressed the content and importance of each of Articles 9 to 11, or the nature and interference, the nature and extent of the interference with those rights, nor do we find him having carried out the balancing exercise, which we know needs...
Doesn't himself address the
content and importance of Articles 9 to 11. He doesn't carry out the balancing exercise, which is a fundamental part of deciding whether the interference was justified or not. And if he'd done so, our simple point is that the court would expect to find passages in his judgment where he carried out that exercise, and setting out why he had concluded in relation to each of Articles 9, 10 and 11 that the interference, which he accepted was significant, why the interference was justified. So that leaves that question simply, well, firstly that means that the judge fell into error in adopting the wrong approach and failing to carry out the exercise, and thus leaves that exercise yet to be carried out. And I think that means that, if your lordships are with me on this point, that it's an exercise that this court will have to carry out. The judge having failed to carry out it himself. I'm going to come back to that question, how your lordship should carry out the exercise and with what conclusion at the end of my submissions, when I get to ground 6.
I think because there are 2 women members of the panel, you're probably better off saying your ladyships rather than your lordships.
Well,
if you were to say that, I would certainly understand that I was included.
Well, this is the first time I've addressed a court with 2 lady justices of appeal, so I'm more used to.
I'm perfectly happy for you to say.
Well, what I'm trying to do is to say your lordship and my ladies. I'm obviously not doing very well, but I'll keep trying if I may. But so unless I can help you further on our second ground of appeal, can I turn to ground 3, which raises the question, were the Article 8 rights of service users engaged? And can I show the court how the judge approached this issue and take you back in his judgment to paragraph 56, page 125. Now, first of all, he sets out Article 8, paragraph 56. Then he sets out some guidance from the Council of Europe Guide to Article 8, which is all pretty familiar stuff. Paragraph 58, he refers to Peck and the United Kingdom. Paragraph 59 to Couderc and France. Paragraph 60 to Murray and Express newspapers. And then in paragraph 61, he sets out his conclusions which I think I can safely invite you to conclude, were in reliance on the authorities which he had just referred to. Can I invite you to note that none of those authorities were relied on, I'm told, by the respondent in the court below in the course of their submissions. So the judge has, as it were, found them in the course of preparing his judgment and then sought to rely upon them. Secondly, as we shall see, they are far removed from the facts of the present case. And thirdly, we submit that they don't support the judge's conclusions. Can I begin with Peck and the United Kingdom, which you will find behind tab 18 of the agreed bundle of authorities. I'm so sorry, you won't find it behind tab 18 at all. Tab 8, thank you very much. Can I try and summarise the facts in a paragraph or two? The applicant went into Brentwood High Street with a knife and attempted to commit suicide by cutting his wrists with the knife. He was filmed by CCTV in possession of the knife, although the CCTV film didn't actually show him attempting to cut his wrists with it. Still photographs were subsequently published in local newspapers from the CCTV film, and footage, that's to say actual film from the CCTV, was subsequently broadcast on local TV. The applicant complained that the disclosure by the council of the relevant CCTV footage which resulted, as it did, in the publication and broadcast of images of him which were identifiable, represented a disproportionate interference with his Article 8 rights. So the first question which arose was whether his Article 8 rights were engaged, and as we see from paragraph 58 of the judgment, the judge quoted from paragraphs 57 and 58 of the judgment, and in particular he relied on the last sentence of paragraph 57, and what is now a well-known expression or phrase: there is therefore a zone of interaction of a person with others, even in a public context, which may fall within the scope of private life. But the decision was that it was not the monitoring of the appellant's actions in a public place which engaged his Article 8 rights, but it was the recording of the data derived from the monitoring and the publication of photographs and actual film from the CCTV data that engaged Article 8. And if I can invite your Lordship and my lady to read on to, or go on in the judgment to page 59, you will see set out the two paragraphs that were cited by the judge. But then what he didn't do was to go on and cite from paragraphs 59 and following, because what we see is from 59 the monitoring of the actions of an individual.
Would you like us to read this?
Yes.
It's quite a long passage, as it's sideline. Would you like us to read this, the whole of the sideline passages?
If your Lordships would, yes please. I think the simplest thing would be to read through to the end of paragraph 63.
Let's do that.
There are just three passages I want to emphasise. Firstly, in paragraph 59, about 6 lines down. On the other hand, the recording of the data and the systematic or permanent nature of the record may give rise to such considerations. And that picks up the last sentence of the passage from PG and JH, quoted in the previous paragraph, paragraph 58. Private life considerations may arise once any systematic or permanent record comes into existence of such material from the public domain. So, no question of any material about these service users being kept or retained or systematically, let alone on a permanent basis. So that's simply, that way of engaging Article 8 simply doesn't arise in the present case. And the next point is to see how the applicant put his case at the end of paragraph 60. He argued that it was the disclosure of that record of his movements to the public in a manner in which he could never have foreseen, which gave rise to such an interference. And then lastly, the conclusion of the court, at the very foot of page 61. As a result, the relevant moment was viewed to an extent which far exceeded any exposure to a passer-by or to a security observation. Just pausing there. So, by inference, exposure only to a passer-by or to some sort of security monitoring observation would not have been sufficient to engage Article 8. And to a degree surpassing that which the applicant could possibly have foreseen when he walked into Brentwood on the relevant date. And thus, Article 8 was engaged and there was a serious interference on it. Now, of course, likewise in the present case, there's no question of any photographs, or indeed the judge didn't decide whether any of the service users had been photographed. But even if they had, there's no evidence that any permanent record was made of any such photographs, let alone that there was any publication at all of any of the service users going to and from the centre. No identification of them, no attempt to identify them, but no identification made of them at all, let alone was their identity published in any way. So we submit that Peck is on its facts completely different to the present case and doesn't begin to support the judge's finding on this issue. Can I then go to his next case, Kudek, which is behind tab 17. This concerned the publication in pari match of allegations that Prince Albert of Monaco had fathered an illegitimate son. And what was published was a long interview with the mother, and it did turn out to be the mother because he accepted in due course that he was the father. A long interview with the mother together with photographs of the child, the mother and Prince Albert. In fact, it was accepted in that case that Article 8 was engaged. The paragraph that the judge quoted from was paragraph 83, which is at page 436 of the bundle. And that's a paragraph that again ends with the now very familiar statement that there is a zone of interaction of a person with others, even in a public context, which may fall within the scope of private life. But what that case was concerned with was publication of the interview and publication of the photographs to a worldwide audience. And that, unsurprisingly, is what the court then went on to address. Starting in paragraph 85, publication of a photograph may thus interfere with a person's private life, even where that person is a public figure. Paragraph 86 begins, in determining whether or not the publication of a photograph interferes with an applicant's right to respect for his or her private life, and so on. And then paragraph 88, which sets out the relevant principles as to Article 10, continues in paragraph 89, at the top of page 438, to address 5 lines down, freedom of expression includes the publication of photographs. This is nonetheless an area in which the protection of the rights and reputation of others takes on particular importance, and so on. So, as I say, this was a completely different case to the present case, and just as with Peck, the United Kingdom provides no support for the judge's conclusions. Whilst we have the case open, the report open, it may be convenient, looking ahead to one of our ground 6, and indeed the Balancing Act, just to show your Lordship and my ladies what the court had to say about the relevant Article 10 principles, so that you've already seen it, we don't have to go back to it. Can I just ask you to read paragraph 88 to yourselves? And I know all that will be well known to your ladyship and my lord in any event, but in paragraph 89 as well, about 5 lines from the bottom of the page, something else which we're well familiar with from Strasbourg case law. Not only does the press have the task of imparting such information and ideas, the public also has a right to receive them. So that's Kudek. Finally, can I turn to Murray?
Yeah, I don't think that particular sentence has much relevance to
It doesn't, but it's reflected in what we'll see in some of the later cases under Article 9, that the right to seek to persuade other people and impart information to other people, rather than is all part of the.
I mean, that particular
applies to the press alone, I agree.
I mean, that particular provision is very much relied upon by people who want to tell other people about the news or stories.
Correct.
That's really what it's concerned with.
Lord, the final case that the judge relied upon is behind tab 12, Murray. And this again concerned the publication of a photograph showing the claimant and her family in a newspaper. One sees letter E. The published photograph showed the 19-month-old claimant being pushed by his father in a pushchair in a public street, with his mother walking alongside on their way to a cafe, and showed the claimant's face in profile, and so on. Now the judge quoted from paragraph 36 of the judgment, which is at page 239 of the bundle. And sought to rely upon paragraph 36. We see that in fact paragraph 36 is addressed to publication cases, and we see that from, unsurprisingly, because this was a publication case, and we see that from the end, and the reference to the circumstances in which and the purposes for which the information came into the hands of the publisher. So, again, that was a case that doesn't provide any support for the judge's conclusions on this part of the case. So the cases he relied upon, none of them, we say, does so. And so with that in mind, then, can I turn to what our submissions are as to the engagement of Article 8 in this case? We submit first that in the present case the service users were at the relevant time in a public place and using a public highway and using a service which was available to the public. Secondly, there was no record of what they were doing. As I've said, the judge proceeded on the basis that they weren't photographed. Third, there was no publication of what they were doing, whether by way of photographs or of any description which identified them. Fourthly, the cases relied on by the judge all concerned publication in some way of the activities in question. Even in Peck, where the appellant was carrying out a very private act, it wasn't the monitoring of that activity by the CCTV which engaged Article 8, but the publication of photographs and the film from it that did. So here, the fact that service users' attendance at the centre was publicly observed by the appellants and by others is, we say, wholly insufficient to engage Article 8. As to their, this is the next submission, as to their expectations of privacy, first we say they were already significantly diminished by the fact that they had chosen to visit a clinic in a public place, access to which was via a public highway. As I understand it, abortion services are available under the NHS in NHS hospitals, and thus if they had sought an abortion or abortion advice under the NHS in an NHS hospital, it wouldn't have been apparent to those observing patients going in and out of the hospital that they were there for abortion procedures or purposes.
So they'd some way waived their right to privacy.
No, lady, I don't say that, but I say that when the court is looking at the extent to which Article 8 was engaged by their attendance at the centre, that is a relevant factor. So they can't have expected not to have been seen or observed by others when doing so, nor in the context of abortion still being a very controversial issue, can they have expected that no one would seek to engage them about that issue when they attended the centre.
Sorry.
Yes. Given the fact that abortion is still a controversial issue, we would add of general public importance, they can't have expected that no one would seek to engage them about the issue when they attended an abortion clinic. We submit that their expectation of privacy cannot have extended that far.
You're really saying that a woman visiting this clinic for the purpose of an abortion should have some expectation that she could be approached, spoken to by someone from a group?
Lady, yes, I do say that. Abortion remains a very controversial issue. We know that it divides the public. We know that there are those who seek to protest in one way or another about it. It's a fact of life that we submit that such an expectation must exist. But what I do accept, lady, is that they can reasonably expect not that their visits will not be recorded or photographed, let alone will any such recording or photograph be published. And that they can also expect not to be identified, in the sense that their identity won't be published, as indeed it wasn't in this case. We readily, can I make it clear, we readily accept that service users may well be at a stage in their lives when, as the judge put it, their sensitivities will be at their highest.
Yes.
And that the fact of being pregnant and the fact that they are or may be seeking abortion services, it may be an abortion itself or information about abortion or advice about abortion, are intensely private matters. I accept all of that. But such private matters don't exist in a vacuum for Article 8 purposes. There needs to be some link between the activity carried out, in this case the, in inverted commas, protests or vigils as they're described by some of the witnesses, and the privacy relied upon.
So there's a danger of confusing two different things here, isn't there? On the one hand, women approaching the clinic would expect a degree of privacy and sensitivity to what they are doing. On the other hand, you've pointed out, and it's well established in the authorities and indeed in this legislation, the importance of the rights of others under Article 10 and Article 11. You've got to be careful not to confuse the question of where there's a tension between the two, the proportionate balance lies at the end of the day. And a separate question about whether or not what is being done to the women as they seek to enter the clinic engages Article 8. And what I'm suggesting to you is you've got to be very careful not to take that latter point, as it were, which ought possibly, to a larger or lesser extent, be part of the balancing exercise.
Well, I readily accept your Lordship's proposition, and I'm endeavouring not to elide the two, and I accept that some of what I'm saying about whether Article 8 is engaged or not will apply no less to the balancing exercise that my Lord refers to. But focusing, as I'm trying to, strictly on the question whether Article 8 was engaged or not.
You might have an expectation that there will be people who don't agree with you
Yes.
on a particular topic, but you seem to be saying, as part of your case, your client's case, that people using this clinic should expect, and therefore should have no expectation of privacy, in relation to much more than somebody who doesn't agree, but actually taking active steps to engage, and everything that implies.
Lord, I do so submit.
Well, that must be the case because the nature of the organisation depends on engagement.
Correct. Engagement at the point of entry.
At the point of entry.
Correct. And without that, then the...
you can't argue it any other way.
No.
You see, you're going so far as to say Article 8 isn't even engaged. That's the point.
It is.
And as my lady says, you have to say that, because unless you, otherwise it becomes more. Otherwise, it then becomes a question of what's the proportionality
Correct.
in working out the order. And that, I think.
So, my lord and my ladies, that is the submission I make. But I was at pains to go on to point out that we don't extend the expectation beyond that to permanent recording, photographing, publication of photographs, identification and the like. And that we submit is an important proviso, or important...
But it must be your case, therefore, that Article 8 is engaged here because anyone using this clinic must properly and reasonably anticipate that everything that was done by the protest group in this case was something they should expect. So it's arranging the praying, it's also the talking to them, approaching them, making suggestions to them. You have to say all of that is something they should anticipate.
Well, what it may be that I do need to go as far as that, but perhaps the question comes down to something rather broader than that. Is there an expectation that, at the very least, there will be those who will seek to engage with them by a variety of means when they attend the abortion clinic, by way of leaflets, by seeking to engage them in conversation, and the like. Now, I mean, if the court was to agree that represented an expectation that those seeking to use the services of the centre should have, then I would submit that for our purposes that's enough to demonstrate that Article 8 isn't engaged, and that the fact that there are some instances of something more invasive, to try and use a neutral word than that, has taken place, wouldn't be enough on its own to convert what would otherwise be the non-engagement of Article 8 into the engagement of Article 8. So the question is, therefore, whether the activities of the appellants engage the service users' Article 8 rights, not whether pregnancy and abortion are private matters. And when I've made the submission, we submit that in the light of what we've said, the answer is no. The judge said that to be the focus of open public attention is an invasion of privacy, even when it occurs in a public space. To be the focus of open public attention is an invasion of privacy, even
Paragraph
when it occurs
were you quoting
in a
from?
public place.
In this judge?
He was going to ask me that, and I haven't noted it. I'm sorry. 61. Thank you very much. I mean, that we submit undoubtedly goes far too far. We submit that's not the law, and he certainly didn't cite any authority that supports it. And as the court will know, there has to be there is a minimum threshold in any event to engage Article 8, and that would fall well below, or well the wrong side of that threshold. And indeed, we haven't been able to find any authority that supports the proposition that merely observing or seeking to engage with a person in a public place or on a public highway engages Article 8. And I don't think there is any such authority in the bundles before you. And we submit that so to hold would have some pretty far-reaching consequences for media activity and protest activity. And by way of an example of the former, I mean, journalists let's take the example of journalists who want to talk to people attending a court about their experience of the criminal justice system, or it may be the civil justice system. Some of those attending may be at a sensitive point. In other words, they may be witnesses, even a defendant, and in some cases they may have been summoned to attend court, so they may have no option but to attend. But could it be suggested that their Article 8 rights were engaged when they do so in a public place via a public highway? Because if so, then in every such instance the Article 8 is going to be engaged, and the journalists are going to have to justify their conduct under, they're seeking to engage those people under paragraph 2 of Article 8. And protest activity, well, we submit that is probably self-evident, and there must be a question mark, we suggest, as to whether this regime of public spaces protection orders is apt to cover protest activity at all. But I may come back to that at a later stage. So, your Ladyship and my Lord, those are the reasons why we say that the judge was wrong to conclude that Article 8 was engaged.
So to summarise here, insofar as in paragraph 61, the judge summarises the principles applicable as being to be the focus of open public attention, often at the very moment sensitive to the House's invasion of privacy, even when it goes in the public place, is too broad and too wide.
That's what we say.
And there's no justification for that. And you say it's sufficient in the present case, however, to avoid the engagement of Article 8, that there was and should have been what I think you described as an expectation of some engagement.
Yes.
And that they could have chosen to go to another clinic that was less exposed.
I mean, I accept that's perhaps not my most attractive point, but it is I believe it to be true nonetheless. Of course, the judge, just as a footnote, as the court would have seen, the judge only found that the Article 8 rights of the service users were engaged. He expressly found that that there was no engagement of the Article 8 rights of those who accompanied the service users, local residents or staff working at the centre.
So where are you reading from now?
63.
63.
Thank you, Melanie. So can I then turn to ground 4? We say that the judge gave too little weight to the appellant's Article 9 rights.
So we're now assuming against you.
You are.
On all the previous grounds.
You are.
So basically what we're doing now is we're looking at the application of a proportionality balancing test.
Well, you're beginning to, but the beginning of the exercise involves this rather curious part of his judgment, where the judge singles out, at this stage of his judgment, the role of religion, in order to downplay it, in the context of the case as a whole. And can I take you to that part of his judgment where he does so? It's page 127. No? 129. That's right. 129 of the judgment. He's just to get your bearings, as it were, beginning at 127. That's why I had the note. He would set out what the Murphy report had said about Articles 9, 10 and 11. And then at page 129, paragraph 65 to 68, there is this short passage in which he singles out, as I put it, the role of religion. He cites an early admissibility decision of the European Commission of Human Rights in the case of Van den Dungen, and then, having done so, and set out what the conclusion was in paragraph 66, he says in paragraph 67, accordingly, the advice given to the defendant on Article 9 was arguably generous to the stance taken by the claimants in this case. Then he turns to Article 14. Furthermore, I'm not persuaded that the application of Article 14 is of salient significance. The PSPO applies to those of all faiths and none, and the reference to prayer is no more than an example of the sort of generically overt behaviour which the order seeks to prohibit, rather than a freestanding discriminatory provision. I will, however, assume, for the sake of argument, that the advice given in the report, insofar as it related to the Christian beliefs of some of the activists, was accurate. It does not, however, follow that the resolution of these issues, either way, would have led me to a different conclusion on the central issues of the case. It would not. The reference to the resolution of these issues, we think, must be a reference to the issues of whether Article 8 and indeed Article 14 were engaged. But he makes it clear that, however they've been resolved, wouldn't have led him to a different conclusion on what he said were the central issues of the case. And it doesn't look from that as though he thought that Article 9 was a central issue in the case. So what we say is that it's tolerably clear from these paragraphs that the judge gave very little weight to Article 9 and the appellant's Article 9 rights.
Can I just ask you this?
Yes.
The judge plainly did recognise, as he had to, the Article 10 and Article 11 rights.
Yes.
As a matter of analysis and in practical reality, what would be added in carrying out the proportionality exercise in adding in Article 9? I'm not trying to diminish Article 9 there, but I'm saying that, you know, if you've got three grounds where there are rights that are engaged, what I call counter rights if you want, Article 9, Article 10, Article 11. I mean, Article 10 is a particularly powerful one, and Article 11 is a particularly powerful one in the context of such an order as this. And without seeking to downplay Article 9, the weight that will carry in any particular case will depend upon the facts. But in a case like this, which is really to do with the right to express your views, the right to protest, what additional weight would Article 9 have carried?
Well, this case is also about the right to manifest one's religion.
Well, as a matter of law, I can see that.
Well, as a matter of fact, because the judge, early in his judgment, at paragraph 5 on page 110.
Well, let me put it a different way.
Yes.
The judge does seem to be somewhat ambivalent, to put it mildly, as to whether Article 9 was engaged at all.
Yes.
But he accepted the parties between themselves said that Article 9 was engaged. Let's assume his somewhat reluctance on that was wrong, and that Article 9 is plainly engaged. The question I'm asking is, what difference would it have made to the outcome once you recognise that Article 10, Article 11 engaged, which are very powerful in themselves?
Well, firstly, if the judge had assessed whether Article 9 was whether there was any justification for any interference with Article 9, he would then have had to, and if he'd answered the question yes, there is no justification for any interference in Article 9, and if he then come to the same conclusions in relation to Article 10 and Article 11, then it would have followed that the interference in question, that the order without justification, had interfered with no less than 3 of the fundamental rights enjoyed by the appellants. That simply what that adds to the reasons why, or demonstrates even more strongly why the order should not have been made. It would not be a case of merely Article 10 or Article 11 or even both dictating that the order should not have been made. It would have been it would have amounted to the making of an order that interfered with the appellant's rights to manifest their religion, right of freedom of expression, and right of assembly. Cumulatively, that would have made the making of the order even more objectionable. I was going to add that, moreover, unless and until one's carried out the Balancing Act in relation to Article 9 and understood the importance of the right to manifest one's religion, certainly I would be very reluctant to accept my Lord's proposition that a finding that Article 9 had been interfered with wouldn't add anything to a similar finding in relation to Articles 10 and 11.
Right, so I'm trying to make it clear it all depends on the facts of each case.
Yes.
There are sometimes, like we get the Awida case and very other similar cases, where manifestation of one's religion is at the forefront.
Yes.
That is the one that is engaged.
Yes.
And it's only one. The only point I'm trying to make is, once you accept, as is obviously the case, that 2 other fundamental rights are engaged, if you were to fail on those, unlike to succeed on Article 9, that's in an awkward kind of way what I'm trying to say.
That may well be true. But unless and until one's carried out the balancing exercise in relation to Article 9,
Yes.
one will never know. And I have to admit that some of what I'm going to say about this part of the case, it is probably directed to the carrying out of the balancing exercise. But it seems to me that it's probably convenient to do it at this stage, whilst the court has in mind the Article 9 rights and the judge's approach to them. Can I take you back to the authority that he relied upon, Van den Dungen, which is behind tab 6 of the Joint Authorities bundle. As I said, it's an early admissibility decision of the Commission, so it by definition carries less weight than a full decision of the court, and you will see from the facts on the first page 37, the facts of the case were that an injunction had been requested against the applicant, prohibiting him from finding himself within 250 metres of the abortion clinic, which is run by the foundation which was applying for the injunction. The foundation alleged that several times per month he addressed visitors and employees as they walked from the car park to the clinic, trying to persuade them not to have an abortion by way of showing them enlarged photographs of fetal remains in combination with images of Christ, by calling abortion child murder and the employees murderers, and by handing out leaflets which also contained photographs. And this led to visitors arriving at the clinic shocked and upset, sometimes to such an extent that treatment had to be postponed. He maintained that he didn't hinder the visitors or employees, that he left them alone if they didn't accept the leaflets handed out to them, but that in any case he had the right to try and stop women from having an abortion, which he deems a crime against humanity as part of his right to freedom of expression. The President holding that the applicant's conduct, well, the President granted the injunction. There were various appeals, and then under complaints, halfway down the page, the applicant submits that the injunction prohibiting them from handing out leaflets and showing photographs which aim at expressing his religiously inspired opinions about abortion in the vicinity of an abortion clinic violates his rights to freedom of thought, conscience and religion and expression. He invokes Articles 9 and 10. And what the Commission had to say about Article 9, third paragraph at the top of page 39, the Commission notes that the applicant's activities were primarily aimed at persuading women not to have an abortion. The Commission considers that the activities at issue do not constitute the expression of a belief within the meaning of Article 9. It follows that this part of the application is manifestly ill-founded. So, a decision very much on its facts. Article...
We need to read the paragraph about Davies.
I'm sorry, my lady.
Sorry, I had my hand over my mouth. The second paragraph down, however, in protecting, is a more general application, isn't it?
I'm sorry, my lady.
Convention doesn't always guarantee the right to behave in the public sphere in a way which is dictated by such a belief. The Commission has constantly held that the term practice in Article 9 does not cover each act which is motivated or influenced by religion or belief. So that's the general proposition.
Yes, my lady. Yes.
Against that, what you were saying,
Yes.
we should be looking at this partly because it's an admissibility decision and partly because it turns very much on its facts.
It does.
But it seems to me that that is a point of general application.
Yes.
I'm not sure where it takes us, but
No.
let's mention it.
No, well, no, that is right. Yes, and one sees that statement of principle in some of the later authorities as well. So, I mean, very much a decision on its facts. Single individual protester distributed in large photographs of fetal remains, called abortion child murder and called the employees murderers. So there are some similarities with the present case. Some, on the other hand, there are some part of the facts aren't similar at all. And we would submit that
There's no more reasoning than that, that's it.
no, that's it. And we would submit that the scope and ambit, and indeed understanding of Article 9, and in particular the right to manifest one's religion, has been enlarged significantly since the decision in Van den Bergen. And we refer to one decision in our skeleton argument, a wider against the UK, and Liberty referred to another in theirs, Barankovic. Can I take you to a wider first? It's behind tab 14 in the joint bundle. And if you go to page 296, paragraph 3, there's a very short summary of the facts. This was the case that involved, amongst others, BA staff who were required to wear a uniform which did not include wearing a cross around their necks. I think that was the first of the applicants. But paragraph 3, the applicants complained that domestic law failed adequately to protect their right to manifest their religion. Ms. Uwaida and Ms. Chaplin complained specifically about restrictions placed by their employers on the wearing of a cross visibly around their necks. And Ms. Liddell and Mr. McFarlane complained specifically about sanctions taken against them by their employers as a result of their concerns about performing services which they considered to condone homosexual union. Can I take you to paragraphs 79 to 82, which begin at page 325. under the heading General Principles under Article 9, the court recalls that as enshrined in Article 9, freedom of thought, conscience and religion is one of the foundations of a democratic society within the meaning of the Convention. In its religious dimension, it is one of the most vital elements that go to make up the identity of believers and their conception of life. But it's also a precious asset for atheists, agnostics, skeptics and the unconcerned, the pluralism indissociable from a democratic society, which has been dearly won over the centuries, depends on it. So that gives us some indication of the importance of the Article 9 rights. Can I pick up the next paragraph, about eight lines down? The manifestation of religious belief may take the form of worship, teaching, practice, and observance. Bearing witness in words and deeds is bound up with the existence of religious convictions, and that, of course, would include prayer. As I'll explain, prayer is an important component of the activities of the appellants and the other members of this group outside the centre. Then I think a passage beginning at 82, which Lady Justice King pointed out, appears in Van der Dengen as well. Even where the belief in question attains the required level of cogency and importance, it cannot be said that every act which is in some way inspired, motivated or influenced by it constitutes a manifestation of the belief. Thus, for example, acts or omissions which do not directly express the belief concerned or which are only remotely connected to a precept of faith fall outside the protection of Article 9. No suggestion that that applies in the present case. And then, after the references to authority, in order to count as a manifestation within the meaning of Article 9, the act in question must be intimately linked to the religion or belief. And then an example, however, the manifestation of religion or belief is not limited to such acts. The existence of a sufficiently close and direct nexus between the act and the underlying belief must be determined on the facts of each case. And I don't think there's any dispute that in the present case, at least some of those who were protesting in inverted commas or taking part in vigils outside the centre did so as a means of manifesting their Christian beliefs, and the judge certainly accepted that. And can I just give you the reference? It's paragraph 5 of his judgment, and the respondent plainly accepted it as well. The reference there being page 81 of the supplementary bundle.
What is that document?
That's the Murphy report to the council members, on the basis of which they decided to impose the DSP. So, my lord and my ladies, you will see that as described in a wider, there is much more to Article 9 than one might have gathered from the Van den Dungen short report. And then the other authority cited by Liberty, one needs to go to their bundle of authorities, tab 16. And the facts probably don't matter very much, but the case concerned the refusal by the authorities to the pastor of a church of evangelical Christians in Chekhov to hold a service of worship in a park. And in fact, a violation of Article 11 was found, but I note that the passage that I was going to take you to is in fact a passage addressed to Article 11. Since I'm coming to Article 11 later, and to save the court having to get this authority out again later, can I, it's a very short passage, paragraph 34. No, there is something about Article 9. I'm not as disorganised as I thought I was. Paragraph 34, towards the end of the report. Yes, this is the passage I had in mind. Finally, the court is not convinced by the government's argument that it was necessary to restrict the applicant's right to freedom of assembly and religion for the protection of those whom he was allegedly trying to convert. Under Article 9, freedom to manifest one's religion includes the right to try to convince one's neighbour, failing which, moreover, freedom to change one's religion or belief enshrined in that article would be likely to remain a dead letter. So, the reach of Article 9, as we submit, clearly moved on since the earlier Commission decision. But the judge failed to move on in the same way in his understanding, in terms of his understanding of the.
Has Vandenbergen been cited as subsequent in any other case?
Well, can we check that over the shorter German and make sure we give your lordship a correct answer? It certainly wasn't referred to in the case I've just shown you, Barankovic, because the authorities referred to in the judgment are set out at.
Don't take up time on it now, as you say.
We'll
over the short German, something for that.
Thank you very much. So, because the judge only relied on an early Commission decision, he failed to appreciate that to the extent that a significant number of those who protested outside the clinic were doing so as an expression of their religious belief. The judge has failed, therefore, to take that critically important point into account in his assessment of the importance or otherwise of Article 9 in this case. Now, my lord and my ladies, I'm about to turn to how we put the case in the court below. So now might be a convenient moment, because I'm going to show you two paragraphs from the skeleton argument for Mr. Justice Turner. But I'm in your hands.
How you put it on what?
On this part of the case.
Well, why don't you show it? We've got 5 minutes.
Certainly. Can I ask you then to go back to the core bundle at page 166.
We're looking at your skeleton argument here.
This is the skeleton argument before the court below. And probably simplest just to invite you all to read paragraph 68. Now, as you will have seen from his judgment, the judge didn't address that argument at all in his judgment. I mean, that point overlaps with what we say about his failure to carry out the balancing exercise at all in relation to any of Articles 9, 10 and 11. And in particular, he failed to address the point made in the final sentence of that paragraph, which is that it's key, as Lady Justice King pointed out earlier, it's key to the activities of the appellants that they are able to engage the service users by being present outside the centre itself. And I showed the court a few moments ago the statement of principle in one of the two more recent Article 9 cases, that the Article 9 right includes the right to try to convince one's neighbour. The other paragraph that I want to show you is paragraph from the skeleton below, is paragraph 71 over the page at page 167, which takes me to prayer. And the judge really had nothing to say about prayer at all in his judgment, notwithstanding that you will have seen from the papers that it represents or represented a key component of the activities that the appellants and others engaged in, often simply silent prayer. And yet he didn't address either the importance of that or did he seek to balance that with the interference caused by the order. As a footnote, as we understand it, this is the first time since the reign of Elizabeth I that any kind of public prayer has been made subject to potential criminal sanction in English law. Now, that some might say that's something of a flourish with which to end my submissions on this part of the case, but my lord, as we understand it, that is the position. So that's what we say in relation to our fourth ground of.
So now we get to the stage where, assuming you've succeeded on 9, Article 9, but lost on the rest.
Yes.
We then get to the balancing act, proportionality.
We do. That is, yes, exactly.
Well, thank you very much. 2 o'clock.
I should comfortably before close of play.
There are a few other points to be made on that. Ranjit, I'm working on citations.
Sorry?
Yeah. There's 2, one of which is mentioned. Yeah, the other is in this one.
Okay.
I'm fine, I don't think it's too much. Would be around
Well, that's a happy outcome. That's excellent. Right.
one of the activities that you mentioned as well, so ask our activities.